Hello, I'm Susan Graham of Senior Edge Legal. And what I want to do in this video is explain to you the estate planning documents when you've chosen a trust-based estate plan. So I'm going to go through the high points of that to make it easier for you to understand how all these pieces fit together. The first part of this video is going to be going through your estate plan notebook that contains all the original documents that you're concerned about, your will, your trust, your financial powers of attorney, your health documents, etc. And then the second part, I'm going to go through the asset and roadmap notebook. So let's start with the first one. And the whole purpose of this, by the way, just to remind you, is just so you can see the high points of this, how they're all interrelated. Because the trust-based estate plan, the trust is the hub of a wheel, and all the rest of that stuff is just to coordinate it so it meets your goals. So the first part in that estate plan notebook is the index, and it has a list of all the assets that are in that notebook. The trust property, which is your deed and homeowner's exemption, your will, the registration that we file with the county, your financial powers of attorney. We have something relating to your electronic documents, your health documents, your living will, and your health power of attorney. And then some detailed instructions to remind you again about how this is all coordinated. So let's get started with the trust. In the trust, I'm going to hit each of the articles and just give you a summary of what's there. Part of the reason I'm doing this for you is when you read through these documents, your eyes glaze over. There's a lot of legalese in here, although I try very hard to keep it in plain, ordinary English. So let's go. Article 1 is the name of the trust. That really is what's the official name of it and who are the people that can sign on behalf of the trust, the money managers or the trustees. You're the one who created it. You're called the trust creator or the grantor. Article 2 is about the trust property. That's the title and the type of assets that you put in the name of the trust. If you're a married person, we also have a designation of how the assets are titled if you want to keep track of separate property and community property. Article 3 is an important article. That deals with how the money's managed for you during your lifetime. But it also says if you're not capable of managing it, how do we have somebody step in without having to go through a conservatorship and guardianship proceeding? Article 4, for a single person, says how's the property distributed after your death. Article 4, for a married couple, says what happens when the first spouse dies. How do we handle the distribution of those assets? Now all these numbers are going to be interchanged, so I'm just going to stick with the married ones, but again, they're identical for the single person. Article 6 is an income and principal article. That just sounds pretty grim, and basically it is. We refer to the Idaho Code. This is for the CPAs to care about. What portion of the assets that generate income are income, what's principal. Article 7 is the trustee's powers. This just says, what can the trustee really do, the money manager of your trust? Again, we refer to the Idaho Code Trustees Powers Act, and we give you a copy of that in these notebooks. But it basically says they can do anything they need to on your behalf. And that means you're doing it first, but then somebody else who steps up later, what can they do? Article 8 is the compensation for the trustee. They're entitled to be paid. But that's silly, you don't want to pay yourself, but it does say that the people who come behind you are entitled to be paid, and it also says they have to provide an accounting. So when you're gone, they have to show what they started with, what came in, what went out, and who's going to get it, and what their amount is. Article 9 is important. This is who's the successor trustee. This means you are probably the original trustee, but who are the people that come behind you, and what order of sequence do they serve? Article 10 is an important article. This says that we call it character distribution. What this means is the inheritance people receive from you, we're keeping it as their sole and separate property. If we don't say that, then their spouses can make a claim against the portion of that inheritance, which most people don't want to have happen. And if that person wants to share it with their spouse, they can do that, but we start out protecting it for them. Article 11 says you can revoke or amend this trust whenever you want. This is a grantor trust or a revocable trust. You can put assets in, you can take assets out, you can change who's the trustee, you can change who the beneficiaries are. So it provides the standards for how that's done. Article 12 is talking about the bond and the liability of the trustee. The people that you're nominating or the entities that you're nominating to handle things for you when you can't do it, you trust them. Otherwise, you wouldn't have nominated them. So we're waiving the bond, meaning they don't have to go get insurance using your money to do that, to guarantee that they're doing what they're supposed to do. And their liability is they have to be conservative of handling your money. They can't go down a jackpot and put it on the table and think they're going to double it. That's irresponsible. Article 13 talks about release of liability. That means when the whole thing is shut down, there are certain standards to be followed so that when the trustee finally distributes the assets out, they're done. Nobody can come back later on and throw a knife in their back and say you didn't do it right. Article 14 has a whole bunch of laundry list things. It's kind of like what's left over in the kitchen sink. It says Idaho law applies and a whole bunch of other things. But we put them in there because they need to be part of your trust agreement. It talks about if somebody fights about it, they don't get any money. It also talks about that if we need to bring a doctor in to declare somebody's incompetent, how those standards are handled. Then you just sign that document. It'll be signed in front of a notary public. Behind that, there's an Exhibit B. That's for who gets your stuff, your china, the rug, the gun. Exhibit A is the list of your the list of the assets that go in the trust, and we never fill that out. The important part is, if you choose to, you can, but the important part is to actually align the titles of your assets with your trust documents. And we'll talk about that just a little bit later, how that we do that for you with your assistance. Exhibit C is relating to any pets that you have, what kind of care you want for those pets when you're gone. Now, let's go through some of the other documents, because then the next section in there is trust property. And trust property, we have a little page that you sign that says you're transferring in all your untitled assets. That's the refrigerator and your china and the sofa. Thank God we don't have to list those things. We also have a deed for any real property that you have in Idaho that you will have signed, and we record it in the county and we get that back to you. For your home, we have you sign something to protect the homeowner's exemption, so you still get the break on the property taxes. Then we move on to a last will and testament. Even though the trust covers what happens when you die, the last will and testament is in case you goofed and left assets outside the trust. There are two kinds of assets: assets you put in the trust during your lifetime and assets that drop in automatically when you die. What I'm talking about is those assets with beneficiary designations. Your life insurance, your retirement accounts, your annuities, they have beneficiaries. But also there are other assets like your bank account. We encourage you to make those paid on death accounts, and we'll talk about that a little bit later. But when you die, again, that will automatically go into your trust. We have the will signed that says if something is left out, you didn't do a beneficiary designation, or there's real property outside the trust, and we have to probate your estate to get that and put it in the trust, the will lists who you want to have do that. Usually it's the same as your successor trustees. We call that person a personal representative. And then there's a sequence of who serves. In addition, we have a section in there that says if something needs to be probated, dump it into the trust. So we have the full plan of how things are handled under the trust agreement. We register. The next tab is a registration and certification of your trust. The law requires that the trust be registered. And what this is it's a short document that says you created a trust, you're in charge, who your backups are as successor trustees. Says how the trust is titled. It also says nothing about what you own or who gets it when you're gone. That's private. We will file that with the court on your behalf, and when we get it back, we'll return it to you. It will come with a case number and a stamp up in the top right-hand corner that records when it was actually filed with the court. The next document is your financial power of attorney. We call them enhanced because we've added extra language to the Idaho statutory form to make it more powerful for you. Basically, this says for the assets that you have outside the trust, who can sign and do modest business on your behalf. You're talking about signing your checks or dealing with selling your car, that kind of thing. So we have that for you to sign. We have the next document is an authorization for release of electronically stored materials. This is the modern age, so we've got passwords, we've got emails, Facebook, those kinds of things. And it all works fine while you're alive and can handle that. But if you're too ill to handle it, that's what this document is for. It says who can access those documents on your behalf. The next tab is for your healthcare documents. This includes your living will and health power of attorney. The living will is a document that says if a doctor says you have a terminal illness or condition and your death is imminent or you're in a processive vegetative state, this means basically you're knocking at death's door. They're out of their ability to help you any longer. And you get all the pain pills you want. You get 3 choices in terms of how you want your terminal last days to be dealt with. The first choice says find all the fancy machines and procedures to keep you going as long as possible. I've had very few people fill that one out. The next one says no, don't bother with that, but give me nutrition and hydration with tubes. I'm talking nose tubes, stomach tubes, out with tubes. And then the third one says don't even bother with that, keep me comfortable and let me go. So you will check one of those boxes. In addition, there's a companion document for healthcare, a power of attorney for healthcare. And this says if you can't communicate effectively with your physician or your healthcare providers, but you're going to get better, who do you want to have talk to them? So you name a first person and then you name some alternate people. So that's what's in this primary estate plan notebook. But now let's go to the Assets and Roadmap notebook. The Assets and Roadmap notebook really has 2 sections. One of it, the first part, is dealing with your titled assets. We're trying to coordinate those with your estate plan so they're either in the trust now or drop in automatically when you die. And then the second part is a whole bunch of things. Your bucket list, your passwords, and so forth. So let me go through the first part about the funding letters. We call them funding letters. These are letters assuming you've given us the information we need to create the letters for you. We have prepared letters for you to sign that we will mail off when you sign all your estate planning documents. When we mail them to these different companies, be expecting you're going to get another form back from them. Every one of these companies have their own team of lawyers. Those lawyers think they need to dream up their own form, so they've got a form that they're in love with. So when you get that form back, complete it and return it to them. If you have any difficulty completing that form, bring that to us and we will help you to be certain that your assets are coordinated. So the first one we have is a bank or credit union letter. And you can tell what these letters are because they say that in the footnote. And basically, we have the information that we mail off to your bank that says, make these bank accounts that I list in this particular letter to be paid on death accounts, meaning POD accounts. It just means your bank statements and your checks stay the same while you're alive, but when you're gone, your successor trustee can go down with a death certificate to that bank, and the bank will close that account and write the check to that trustee of your trust. And that can be put in the trust account and handled according to your distribution. Some of our clients have certificates of deposit that they want to put in the trust name now or make POD, paid on death, so we have a letter for that. For life insurance, we have a letter to mail off that says who's the primary and who's the contingent beneficiary. So if you name the primary beneficiary my spouse, and that spouse predeceases you, who's the one who gets the money? So often it's the spouse first and then the trust is the contingent beneficiary. Again, remember, we want the trust to be the beneficiary because that's the big plan. It talks about it goes equally among these people, and if somebody predeceases you, what happens with that share? So that's why it's useful to coordinate it with your trust. We have annuity letters. An annuity letter says you've got an annuity, and again, maybe you have a $100,000 annuity. Who's the first beneficiary? So you name a primary beneficiary and then a contingent beneficiary. If you name a human for the primary beneficiary, a spouse or a friend or a child, then you need to, again, have the trust be the contingent beneficiary. Or you may want to have the trust be the primary beneficiary. There are IRA letters, pension letters, deferred comp, 401k letters. These are all retirement accounts where the money's been put in and no income tax was paid, and when it comes out, there's tax due. Those are handled slightly differently. So we have beneficiary designations for those that we've done to reflect what you said you want to accomplish. There's a brokerage letter. So if you have a brokerage account, we want to put that brokerage account in the name of the trust. And that letter instructs the broker on what to do with that account. That one, I guarantee you're going to get a letter back, a separate document to complete with the brokerage company. Same thing for any stock certificates you have. So if you physically hold the stock certificates or you have an account that's reflected in terms of how many shares of stock you own with someone, again, we want to get that in the name of the trust. Same thing for U.S. savings bonds or money market accounts that you might have, mutual funds that you have. Again, these are letters to get those assets titled in the name of the trust now. We have a letter to send to the insurance company that insures your home and any other real property that you own to make sure that they know that the insurance policy should cover your home and in the name of the trust, as well as you individually or you and your spouse individually. We don't want to play a game with the insurance company if there should be a fire in the home, that they say we never knew about the trust, so we're not covering it for the insurance. There should be no additional fee with the insurance company for doing that. If you own real property outside the state of Idaho, many of our clients ask us to assist working with that attorney outside of Idaho to help arrange for that property to be transferred into their trust. So that's the list of the asset transfer documents or asset funding letters that we prepare for you. We fill out the specific ones that you need based on the information you've given us. We also provide a whole series of blank forms for you to use for future assets you acquire. Now, the next part of this notebook is a laundry list of things that you may choose to fill out or not. And that's for you to decide. We also will prepare a flash drive and have blank forms for you to fill out on the computer if you choose to do that. But again, you need to print them off, date them, and mail them in. We have a bucket list. You might as well fill it out, for heaven's sakes. What are you waiting for? And start checking those things off. What are the fun things you want to do for yourself or your family before you're gone? We have a family information sheet. This is information that your family, if you don't choose to prepare your obituary ahead of time, that your family may look to provide information that actually goes into your obituary. We have people to notify if you become seriously ill or when you die. I was visiting a college friend in Boston, and I visit her every few years, and she asked me, "How will I ever know, Susan, when you die?" I thought that was a great question, so I came back and prepared this document. And shortly thereafter, I was administering an estate for a friend of mine who was also a client, who died, a widower with no children. He died in October, and he had an address book that was a mess, and we never talked about who to notify. And I didn't know. And by the way, if you looked in my own address book, you wouldn't know who to notify. I've got dead people in there, I've got people, I don't even know who they are anymore. So that's not very helpful. What happened, Christmas cards started coming in to him because I had the address changed to my address. And I wrote to everyone and told them that he had died and gave them some other information. I received many sweet notes coming back thanking me for that information. So this is a place to provide who to contact. If you have not made your funeral arrangements, we have a document called a remains letter that you can indicate what you want when you're gone for how your body should be handled and any celebrations. We have a list for your professional providers or advisors to fill out. Who's your dentist? Who's your CPA? Those kinds of things. We have information for you to list about your credit cards and your charge cards so that they know where they really are. We have a list for password information or where you find it. You can make it a treasure hunt, but at least give them a hint on where they can go looking for it, because that becomes a big problem when people pass and nobody can get to it. We have a driver's agreement. I think most of my clients hate this document. That's a document to fill out to say, when should you stop driving? Again, you don't have to fill out any of these forms, but they just make it easier for people that you have elected to come back behind you and help you when you can no longer handle your affairs effectively. We have something for, we call it My True Wealth. It's just a form to start, to tell your stories to people. We only have one page. I had a lady say, "This is way too much information. There's too much space for me." And that seemed a little over the top, but we also have had people complain it's not long enough. This is not intended to be all-inclusive. This is, you might say for your children, what was the best day? What did I most admire about you? What was the worst day in your life? Whatever you feel you want to share with your family, that would be a place to get started. We have information for you on organizing your records, what you need to keep, for how long you need to keep it, what kind of stuff you need to keep forever. We have a number of other documents that are in this section that you may or may not choose to fill out. We also have the Idaho Trustees Powers Act, that if you we refer to that, as I mentioned earlier, in the trust document. And sometimes there's some bank that needs to see that, so you can just give them a copy. We also have some information on authority in absence or uncovered provisions in a prearranged funeral plan. That is information on who has priorities to make choices about your remains when you're gone if you haven't prearranged that, because sometimes there are arguments in families about what to do when someone passes. And lastly, we have a trustee's checklist. We have something for your successor trustee to look at so that they have some guidance about what to do when they need to step up and assume their duties. So I hope this has been a help to you. My whole purpose in this is to try to make this understandable about how all these documents interrelate to effectively enforce the estate plan that you want to set up. Thank you for working with us.